If there is any change in the list of members of the general body of the society referred to in subsection in bracket 21 on account of induction, removal, resignation or death of any member, a modified list of members of general body shall be filed with the registrar within 1 month from the date of change. Full stop para. The list of members of the general body to be filed with the registrar under this section shall be signed by 2 office bearers and 2 executive members of the society. Full stop para. Member defined. For the purposes of this act, a member of society shall be a person who, having been admitted therein according to the rules and regulations thereof, shall have paid a subscription or shall have signed the roll or list of members thereof, and shall not have resigned in accordance with such rules and regulations, para. Disqualified members. But in all proceedings under this act, no person shall be entitled to vote or be counted as a member whose subscription at the time shall have been in arrears for a period exceeding 3 months. Full stop para. Every society shall maintain a register of members giving such particulars as may be prescribed. Full stop para. From the plain language of section 4-B in bracket 1, it is clear that the registrar is conferred with the power to examine the correctness of the list of members of the general body of the society on the basis of the register of the members of the general body and minutes book thereof, cash book, receipt book of membership fee and bank passbook of the society. Full stop. The criteria on the basis of which the registrar / deputy registrar is to examine the correctness of membership is well defined under section 4-B, which has come to be inserted by UP Amendment Act number 23 of 2013 with effect from 9.10.2013. Full stop para. The word examine is not defined under the Act in the context in which it has been used in the newly inserted provision. Full stop. Even the rules framed thereunder do not define the word examine, therefore it has to be understood within its dictionary meaning. Full stop. Black's Law Dictionary defines the word examine to be typically equivalent with observe or analyze or inspect. Full stop. Also synonymous with review when examining a document. Full stop para. Once a statutory provision confers power on an authority by setting out its limits or the area within which correctness of a decision is to be traced, whether such power culminates into the determination of right of a party against another party who may have a rival claim on the issue. Full stop. In other words, can the power conferred under section 4-B of the Act be interpreted to be quasi-judicial? Full stop. The quasi-judicial decision as understood in the context of English decision, that is Cooper versus Wilson in bracket 1937 KB 309 1937 is defined as under para. The definition of a quasi-judicial decision clearly suggests that there must be 2 or more contending parties and an outside authority to decide those disputes. Full stop para. Applying the above definition and triple test within the 4 corners of section 4-B to the issues involved in the present case, it is quite clear that the decision-making authority of the registrar / deputy registrar is not contemplated in the provision, but what is contemplated is an administrative exercise of power, full stop. The membership disputes, as is well settled, are amenable to the jurisdiction of civil court in a civil suit, and that apart the language of section 4-B, in my considered opinion, does not divest the civil court of this dominion either expressly or by implication, para. From a perusal of the order dated 17.10.2014, it is amply clear that the deputy registrar has entered into the validity of membership disputes with respect to several trustees under section 4-B of the Act, and the impugned order by recognizing the election of membership of those members against whom serious objections have been raised on either side, once having given rise to election disputes in relation to office bearers of the governing body, the deputy registrar ought to have referred the dispute to the prescribed authority, full stop. Failure on the part of the deputy registrar to refer the disputes to the prescribed authority by assuming jurisdiction under section 4-B is therefore, clearly beyond the scope of said provision, hence without jurisdiction, full stop, para. Not only that the impugned order is without jurisdiction, but even on the administrative side, the deputy registrar has not applied mind on the relevant aspects as to whether the election of new members was at all held by following due procedure under bylaws, and whether the removal of any existing member was carried out by following the mandatory provision of clause 6 (5) of the bylaws, full stop. This court, on close examination of the record, is satisfied that the impugned decision of the deputy registrar is tainted by arbitrariness, full stop. All these aspects have completely escaped the attention of deputy registrar while examining the dispute, though he was duty bound to read the bylaws in the manner recorded herein above. For making a reference, therefore, on this account also, the decision arrived at lacks due application of mind, rendering the order as illegal, full stop, para. In writ petition number 71 (MS) of 2015, the petitioner, while assailing the order dated 3.1.2015, has again assailed the jurisdiction of the deputy registrar to refuse making of reference of the rival disputes which were clearly noticed by him, full stop. For appreciating the arguments advanced, relevant portion of the operative part of the order dated 3.1.2015 is learned counsel for the petitioner, while assailing the order dated 3.1.2015, has argued that once two rival disputes as regards constitution of governing body had come to the notice of deputy registrar, as is sufficiently evident from the operative part of the impugned order, it was incumbent on the part of the deputy registrar to refer the dispute to the prescribed authority by exercising power vested in him under section 25 (2) read with section 4-B of the Societies Registration Act, full stop, para. Further submission of learned counsel for the petitioner is that a plea was also raised before the deputy registrar to the effect that 1/4 of the members have already raised a dispute before the prescribed authority. Therefore, the deputy registrar may not look into the rival disputes as regards the election dispute of office bearers of governing body, and for that reason the matter may not be decided either way, full stop, para. Learned counsel appearing for the respondents In reply to the arguments advanced by learned counsel for the petitioner, submitted that as far as the exercise of power vested under section 25 in bracket 2 is concerned, it was open to the deputy registrar to look into the bona fides of the dispute, and only on being satisfied, the matter could be referred to the prescribed authority, full stop. Once the deputy registrar has applied mind and recorded a categorical finding that bona fide dispute regarding management does not exist, the obligation on the part of the deputy registrar to refer the dispute to the prescribed authority was not warranted in the facts and circumstances of the case, therefore the impugned order dated 3.1.2015 is valid and does not suffer from any illegality, full stop. As far as dissatisfaction regarding 1/4 of the members is concerned, learned counsel has further argued that to this extent also the observation of the deputy registrar is tenable, in as much as having regard to the list approved wide order dated 17.10.2014, the strength of members was clearly short of 1/4. Therefore, the deputy registrar had exercised his jurisdiction in consonance of law, full stop, over.